My name is Michael Waddington, and I'm a military defense lawyer. In a military sexual assault case, there are multiple defenses that you can raise. One of the most important defenses in a military sexual assault case is mistake of fact. And that defense basically is this. If you engage in sexual behaviors or sexual relations with somebody, and then they later turn and say that you sexually assaulted them or raped them or committed some sort of a sex crime against them, then the prosecution must prove beyond a reasonable doubt that you committed that offense, meaning they have to prove beyond a reasonable doubt each and every element of the sexual assault allegation. And the defense can raise through evidence, you can't just make it up, there has to be evidence on the record in the trial of mistake of fact on behalf of the accused. What that means is from the perspective of the accused, the person engaging in the sexual relations, the government must prove not only they committed the crime, but they must prove beyond a reasonable doubt that that person that's being accused did not have a mistaken belief that the person was consenting. But in order for someone to be held criminally liable for a military sexual assault, that person must know that they are committing a crime. It has to be a reasonable mistake of fact based on the circumstances. So I'm going to explain what a reasonable mistake of fact to sexual assault would be. Let's say I'm in college and I meet someone in the dorm and we go to lunch, we hang out, I think she likes me, she flirts with me, we watch movies in her bed late at night, and we kiss a few times. And let's say I then invite her to the movies. And I take this woman on this date to the movies, and we're sitting there watching a romantic movie, and she's cuddling into me, and I think everything's great. And I put my hand on her leg, and I start rubbing her leg, and I start rubbing her inner thigh. She doesn't say stop, doesn't say no, doesn't say anything. And I think that she's reciprocating. She's kind of, smiling and making soft sounds like or whatever a person makes in that situation. But you get my point, that if the person seems to be reciprocating and not resisting and the person is consenting, then in the mind of the person that's doing the touching, they are not committing a crime. And so let's say 2 weeks later that the woman that was at the movie theater who had her leg and her thigh touched says, when I was sexually assaulted at the movie theater, I didn't verbally tell that man, the guy, that he could touch me. And let's say a charge comes from that. And charges do come from this. We've done plenty of cases like this. When we get to court, we're going to raise evidence on cross-examination and potentially through our client to show what the state of the mind of the accused was. So from the state of the mind of the accused, he's thinking, I like her, she likes me, we text each other all the time, we hang out together. I think we are talking, as they say nowadays, which is equivalent to dating or seeing each other from those of us that are older than 40. But if you're talking or seeing someone and you think that they are willing and wanting your sexual advances and you then touch them and you have no indication that it is not consensual, then you are not guilty of the crime. So in order to convict you, the prosecution must prove that not only you committed the crime, but that you did not have a mistake in your mind as to whether or not the person was consenting. And they have to prove that beyond a reasonable doubt. So it's like a double hurdle. One of the best things you can do in a case like that, where you're engaged in sexual relations with someone and you think they're consenting, and if you get charged, is to talk to a lawyer who specializes in sexual assault or military sexual assault defense and explain your situation to that lawyer so that that lawyer can advise you on your defenses to sexual assault in the military, such as mistake of fact. That's one of the biggest ones. The lawyer can advise you on your options and how to present that defense to military sexual assault at a trial. What you don't want to do if you engage in sexual behavior with someone and they're accusing you, is to go in and start talking to the police and saying you never touched them and lying and saying you never touched them or just making up excuses about why you touched them, because what you may be doing is shutting down potential defenses. Often the truth is the best defense, believe it or not, in these types of cases where there's a mistake about whether the person is consenting or not consenting. On that note, for all you haters out there, obviously you shouldn't be going around sexually assaulting people in having sex with or touching people that you don't know. Obviously, that was probably going to be a crime. I'm talking about situations where the people know each other, where there's some sort of back history, where there's some sort of touching and consensual behaviors that would lead a reasonable person to believe that the person they're touching is in fact consenting. I'll give you another fact pattern where mistake of fact as to consent to a military sexual assault would not apply. Let's say you're a sergeant and you see a young, new E1 who comes in your office who's very attractive and you think they're sexy, and you walk up to them and put your hand on their buttocks. Don't know them, it's in the workplace, the person has never even spoken to you, or all they've done is basically talk to you and said, hey sergeant, how's it going? There is no mistake of fact there. Looking at someone, smiling at someone, being friendly with someone is not going to raise mistake of fact as to consent. There has to be some sort of reasonable expectation that the person's going to consent, such as a pre-existing relationship, some sort of pre-existing sexual history between the two of you. And it doesn't have to be long-standing history. It could be someone you met at the bar that night that was talking with you, flirting with you, and agreed to go back to your place and then started engaging in sexual behavior. That would be enough, usually, to raise the mistake of fact as to consent as a defense to military sexual assault. Bottom line is, before you go and hook up with people, be very careful. Make sure you do get consent to avoid this sort of situation of being falsely accused of military sexual assault or any type of sexual assault. And if you do happen to get accused, then you need to talk to an experienced court-martial lawyer who has experience defending military sexual assault cases for at least 10 years or more to bring that firepower and that experience to your case to help defend you.